Hi students, I'm recording Law of Contract Unit 1. I had recorded part 3 previously and this is part 4. In part 3 we looked at various types of contracts where we looked at the first contract on the basis of creation, and then we looked at contracts on the basis of execution, and the third one was contracts on the basis of enforceability. And I think that's where I ended part 3. So contracts on the basis of enforceability are 6 types. I'm just reading it again. One is valid contract. Valid contract is one which satisfies all the conditions prescribed by law. For example, marriage, offer and acceptance by two parties. Voidable contract under section 2(1) is one which is enforceable by law at the option of one or more of the parties thereon, but not at the option of the other or others. Consent of one party is normally obtained by coercion or undue influence or fraud or misrepresentation. Repudiation must take place within a reasonable time. The consequences of rescission of voidable contract. Section 64 says that when a person at whose option a contract is voidable rescinds it, the other party thereto need not perform any promise therein contained in which he is a promiser. If the party rescinding the contract has received any benefit from another party to such contract, he must restore such benefit. Example, when a contract for sale of a house is avoided on the ground of undue influence, any money received on account of the price must be refunded. Third, void contract. So this is a third contract under, it comes under, wait, what? Sorry. So this is the third contract and it comes under contracts on the basis of enforceability. And so the first one was contracts under enforceability. I said were 6 types. One is valid contract, voidable contract, and now we are looking at void contract under section 2 within brackets J. So this is one which ceases to be enforceable by law and hence becomes void. Actually, it was valid when entered into but subsequently becomes void due to A. Impossibility of performance, B. Change of law, or C. Some other reason. For example, death of a party to a marriage. Fourth, void agreement under section 2 within brackets G is one which is not enforceable by law, that is void right from the time it is made. For example, a contract with a minor or a person of unsound mind. It is void it is void, and the next word I don't know what it means, but you can find from your professor. It says it is void ab dash initio, INITIO, and does not give rise to any legal consequences. Difference between void and voidable contracts. Now there are a total of 8 differences between void and voidable contracts. So they are different in many aspects. First, definition. Void contract is a contract which ceases to be enforceable by law, becomes void when it ceases to be enforceable. Section 2J. Voidable contract. A voidable contract is an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the others. Section 2(1) or I think it must be I. Anyway, then the difference between void and voidable contracts in terms of nature and validity. In terms of nature and validity, a void contract is valid and binding upon the parties when entered into, but subsequent to its formation, it becomes unenforceable due to certain reasons. Voidable contract is repudiable at the option of the aggrieved party. It remains a valid contract until it is set aside or rescinded by the party entitled to do so. Third difference between void and voidable contracts relates to factors responsible. A valid contract may become void due to supervening impossibility, change of law, a contingent contract due to emergence of an uncertain event, etc. A voidable contract, coercion, undue influence, error, fraud, misrepresentation are the main factors responsible for rendering contract voidable. Difference between void and voidable contract in relation to, fourth point is enforceability, in relation to enforceability. Void contract, it cannot be enforced by either party, but voidable contract, it may be enforced or set aside at the option of the aggrieved party. Difference between void and voidable contracts in relation to relationship. So the fifth is relationship. A void contract under no circumstances results in a voidable contract. When a voidable contract is rejected by the aggrieved party, it results in a void contract. Difference between void and voidable contracts in relation to rights of third party. A void contract confers no rights or legal remedies to the third party. Voidable contracts, rights acquired under voidable contract by an innocent third party are not wiped out by such subsequent avoidance of the contract. Difference between void and voidable contracts in relation to compensation, which is the seventh point. In case of void contract, question of compensation or damages does not arise on the non-performance of such contract. In case of voidable contracts, the party rescinding the contract can also claim damages. Difference between void and voidable contracts in relation to effect of lapse of time. Under void contract, lapse of reasonable time does not render a void contract enforceable. It always remains void, that is enforceable. Voidable contract is not rescinded by the aggrieved. If a voidable contract is not rescinded by the aggrieved party within reasonable time, it may become enforceable at the option of the other party, that is, who induced the contract. So these are the differences between void and voidable contracts. I read a total of 8 differences. One pertaining to definition, second was nature and validity, third was factors responsible, fourth enforceability, fifth relationship, sixth rights of third party, seventh compensation, and eighth effect of lapse of time. So we looked at how voidable and voidable contracts, void contracts and voidable contracts are different in relation to these 8 points. So we are continuing with various type of contracts. Illegal agreement, number 5. I don't know what this is, but anyway, it says 5. Illegal agreement is one the object of which is illegal and hence is voided from the very beginning. For example, agreement between two persons to kill a third person. In such a case, even collateral agreements are also void. Sixth, unenforceable contract is one which is valid but cannot be enforced due to technical defect such as not in writing or understamped. After removal of a technical defect, it can be enforced. For example, an oral agreement for arbitration is enforceable, but if reduced to writing, it can be. I'll read it again. For example, an oral agreement for arbitration is unenforceable, but if reduced to writing, it can be enforced. So these 6 points all relate to the enforceability of, I think they're all related to what? Yeah, contracts on the basis of enforceability. There were 6 types: valid contract, voidable contract, void contract, valid contract, voidable contract, void contract, void agreement, illegal agreement, and lastly unenforceable contract. So we looked at all these 6 types, and we looked at the differences of void and voidable contract. And now what we are looking at, base of difference of void agreement and void contract. We're looking at the differences between void agreement and void contract. So the first base of difference between void agreement and void contract is void ab initio. No, so I'll spell it because I don't know what word this is. VOID, void, ab, EB hyphen INTIO, intio or intio, how do I pronounce it? Void ab intio, based on this, the difference between void agreement and void contract. On this aspect, the aspect of void ab intio, void agreement, it is void from the very beginning, but in void contract, it is valid when made and continues to remain valid till it is repudiated by the aggrieved party. It becomes unenforceable later on. Second difference relates to which essential element of contract is missing. In void agreement, it is void because an essential element of a valid contract is missing. Void contract, it is voidable because the consent of a party is not free. The fourth point we are looking at is in relation to enforceability. In void agreement, it cannot be enforced by any party. In void contract, it continues to be enforceable if the aggrieved party does not repudiate the contract. Right of third party. We are looking at the difference in terms of right of third party. In void agreement, third party does not acquire any rights. But in void contract, a third party who purchases goods in good faith and for consideration before the contract is repudiated acquires good title of those goods. Next, we are looking at in terms of treatment, the difference between void agreement and void contract in terms of treatment. Void agreements have been specifically stated in Chapter 2 of the Act under Sections 11, 20, 23 to 30 and 56. Void contract, on the other hand, no such specific mention is made to void contract in any chapter of the Act. Basis of difference between void agreement and void contract in relation to rights. A void agreement does not create any legal right or obligation upon the parties to the agreement. Void contract. On the other hand, a void contract does create a right and an obligation upon the parties. A party to the void contract is within his rights to get back the benefit of which he had given to the other party in terms of money, goods or services, and the other party enjoying such benefit under a void contract is placed under an obligation to return that benefit. Basis of difference between void agreement and void contract in relation to damage. The question of damages does not arise under void agreement. In void contract, the aggrieved party can claim damages. Now I'll stop here because it's become too long, but in the next part, which is part 5, I will be looking at difference. I'll be recording difference between void agreement and illegal agreement.